Hi, Shane. Hi, Khaled, Nicholas. Great to see you. Good to see people filing into the room. Just going to give it a moment before we begin. I can see people are still just kind of coming in. Hello, everybody. Good afternoon. This is our event. Why should Naftali Bennett be barred from Canada? We're joined today by Khaled Muammar, Michael Link, Shane Martinez, and Nicholas Pope. Welcome, 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 Khaled, Shane, Nicholas, Michael. Again, you're here for why should Naftali Bennett be barred from Canada? So my name is Bianca. I'm with the Canadian Foreign Policy Institute, which is one of the co-sponsors of this discussion. I'm speaking from Montreal, or Jojage, which is on the territory of the Kanien'kehá:ka people. I want to thank the organizations that have sponsored today's event and for the terrific work that they've done to bring this together. So that's Just Peace Advocates and PAJU alongside CFPI. I also want to thank the 40 organizations who've endorsed the campaign that we'll be talking about tonight, and the 1,200 people who've written letters requesting that Naftali Bennett be banned for his deep involvement in the development of illegal settlements in the Palestinian West Bank. So there will be lots of links and resources that will be posted in our chat. Karen Rodman from Just Peace Advocates will be helping with this, and you can also direct any technical questions that you may have to her. After hearing from our panelists, we're going to have a brief question period where we're going to take questions from journalists. So if there are any present, and if time permits, we may also be able to take some questions from the audience. So if you are a journalist, please do identify yourself in the chat and let us know what organization you're with. So the webinar is going to be in English, but if there are any French journalists, we do have translation available. So again, as I said, we're live on Zoom and Facebook. If you want to share this broadcast, that would be great. More people can see it. Just go to facebook.com/Canada Policy, and I can see that. And yes, yeah, Karen will be putting that in the chat as well. So for the chat, it's open. We love to hear from you. Please do keep your comments civil and free from harmful commentary as always. But yeah, please do say hi and tell us what traditional territories you're tuning in from. So today's event, why should Naftali Bennett be barred from Canada? This is an important question. It's part of a successful campaign to intervene and call into question the former Israeli Prime Minister's planned speech in Toronto, which is planned for tomorrow. So the hope is that the Canadian government will uphold its responsibilities to bar Bennett. But even if that doesn't happen, lawyers Shane Martinez and Nicholas Pope, who are here, really deserve serious congratulations for their legal work on this case. Their legal brief to bar Bennett from Canada has been covered by CBC, the Israel National News, the Middle East Monitor, the World Israel News, Socialist Project, Jordan News, Palestine Chronicle, Jurist, Radio Canada International, and other outlets. And today, the CJN published an article stating, open quote, Israel's former Prime Minister, Naftali Bennett, says he has purposely taken steps to keep a lower profile ahead of his speech in Canada this Wednesday. He hasn't posted anything to his 500,000 followers on Twitter or Facebook since June 3rd. Bennett also declined a request by the CJN Daily to do a podcast. He agreed only to appear in a print story with this in the CJN in advance of his appearance in Toronto. They go on to say that he wouldn't say why, but that it now appears it could have something to do with efforts to have Israel's 13th leader banned from entering Canada for his scheduled talk on Israel at 75 on behalf of the Friends of Simon Wiesenthal Center. So this legal brief is clearly making waves, and we are very fortunate today to be joined by a number of speakers who will let us know more about why exactly former Israeli PM Naftali Bennett should be barred from Canada. And the first speaker of the afternoon is Khaled Muammar. Khaled is a Palestinian-Canadian, founder of the Canadian Arab Foundation, and former member of the Immigration Refugee Board of Canada, as well as a signatory to the request. Welcome, Khaled. You'll just have to unmute yourself, Khaled. You're still on mute. Yeah.
Okay, thank you, Bianca. Well, I'm really pleased to be able to join on this podcasts regarding the visit of Naftali Bennett for two reasons. First of all, I myself am a refugee who was forced to leave my country in 1948 due to the policies of the British occupation forces at that time, which resulted in the end in having armed militia of the Haganah go into the city of Haifa, where I lived at that time, whose population was 50% Palestinian Arabs, and they were able to expel most of them except for 2,000. And my family was one of the ones who were forced to leave and go to Lebanon. And since then, we have not been allowed to return. Now we have 5 million of my people in East Jerusalem, the West Bank, and Gaza, who have been under Israeli control and rule for 56 years. This is a country now which is a nuclear power, whose military is actually more powerful than Canada's military. And it advocates at the same time Jewish supremacy between the Jordan River and the Mediterranean Sea, which means they are offering the Palestinian people only two options. Either you accept this situation of an apartheid regime, or you are going to be deported. So the actions of people like Naftali Bennett are serious in the sense that he was instrumental in establishing and expanding illegal settlements in the territories which were under Israel occupation since 1967, prior to becoming prime minister and later as prime minister. And therefore, if Canada is to abide by international law and by its own laws, they should make a point that he is not allowed to enter Canada, because this will discourage people who are committing war crimes and crimes against humanity from doing it again. Otherwise, he will be encouraged, and people like him, like other ministers now in the current government, like Bezalel Smotrich, who's in charge of the civil administration in the West Bank, would continue with their policy to Judaize the West Bank and East Jerusalem and even the Galilee and the Negev inside Israel, to Judaize those. And if anybody objects to that, he is liable to be detained, imprisoned, or deported. So we are dealing with a serious situation in the sense that since 1967, Israel has moved 500,000 illegal settlers into the West Bank and another 230,000 settlers to East Jerusalem. And these are mostly in colonies. So you have about 300 colonies in these occupied areas, which are half of them are really illegal outposts, but they have been allowed to exist. And most of them were built on areas which the military, Israeli military, declared as firing zones, and therefore does not allow Palestinians to go into these areas and actually restricts them. Now we're talking of an area in the West Bank which comprises 61% of the area of the West Bank. It's called Area C. Currently, there are now there 500,000 illegal Jewish Israelis, and at the same time, you have 200 Palestinian communities which are being choked slowly. And most of them are really people who live on farming and herding, and that's why Israel wants to annex that area after it had annexed Jerusalem in 1980. And to be able to annex that area, they want to ensure that the population there is a majority Jewish. So currently there are 300,000 Palestinians in Area C, and they have slowly been choking these communities, taking the lands from them, the grazing lands for the sheep, agricultural land, and this way they hope that the pressure will force these people to look for safety for their children who are being attacked, and also for livelihood, because their livelihood has been strongly impacted, and force them to move into areas A and B, which are smaller areas. So by doing that, they would ensure that they would have a major Jewish demographic majority in Area C, to enable them to annex it formally, because actually de facto they have annexed it, but they are proceeding with moving more and more illegal settlers in those areas, and using harsher and harsher measures to make life unbearable for the 300,000 Palestinians in Area C. So this is a serious matter. A person who is responsible for establishing and expanding these settlements, like Naftali Bennett, should be barred from entering Canada, and send a clear message that Canada is abiding by its own laws, by the Immigration and Refugee Protection Act, and also by the Rome Statute of the International Criminal Court, which prevents both the transfer of its citizens to the occupied areas, and at the same time prevents it from deporting the Palestinian inhabitants of these areas from one place to another, and in some instances to force them actually to leave all of Palestine between the river and the Mediterranean Sea. So we hope that our government does not only talk the talk, but walk the walk, and implement its laws and policies, so that this sends a clear message everywhere that we will not accept crimes, war crimes, and crimes against humanity against not only Ukrainians, but also Palestinians. After all, we are all human beings, and according to our Charter of Rights and Freedom, there is no distinction between Canadians or anybody based on their race, religion, ethnicity, political opinion, or gender. So we wait for a favorable decision from the Trudeau government. Thank you.
Thank you. Thank you so much, Khaled. Thank you for your comments. Thank you for the important critical background, and underscoring Bennett's specific responsibility for expanding these settlements and its impacts, and for the call for accountability for his war crimes. We look forward to hearing more from you in the Q&A period. Our next speaker is Michael Link. Michael Link is a professor emeritus at the University of Western Ontario and former special UN rapporteur for occupied Palestine. Michael provided a comprehensive statement that was included in the request to the CBSA. Welcome, Michael.
Thank you very much for this, and thank you for organizing this conference. As Bianca's mentioned, I am the former United Nations Special Rapporteur with respect to human rights in the occupied Palestinian territory. In that capacity, which I served between 2016 and 2022, I delivered a number of reports both to the UN General Assembly in New York and to the UN Human Rights Council in Geneva. And in the course of doing that, I wrote quite often about the settlements, and I had plenty of opportunity to be able to speak about and to write about the legal status of the Israeli settlements. So in my short remarks today, I have three things that I want to be able to put across. The first is that the Israeli settlements are illegal under international law. There is probably no other issue in modern international relations where there's such a wall-to-wall consensus in the international community than there is with respect to the illegality of the Israeli settlements. This has been expressed, I believe, in over 160 UN General Assembly resolutions since the early 1970s. It's also been expressed in a number of Security Council resolutions as well. The settlements are illegal under the Fourth Geneva Convention of 1949, which forbids an occupying power, which is clearly Israel, with respect to the Palestinian territory. It forbids an occupying power from transferring any parts of its own civilian population into the territory it occupies. And the whole point about that is to ensure that the occupying power doesn't view the occupied territory as a fruit of conquest and begins to move parts of its own civilian population in order to be able to demographically engineer a legal and political and social change in the status of that particular territory. And this was emphasized most recently by the UN Security Council in Resolution 2334 in December 2016, at the very end of the Obama administration, when the Security Council adopted this resolution, and it said that the Israeli settlements in the West Bank and in East Jerusalem are a flagrant violation under international law. That's a direct quote from the resolution. And as well, the fact that the Israeli settlements are illegal under international law is a long-standing Canadian policy as well, which has survived through policy and changes and administrative changes over the last 25 years in Canadian politics. The long-standing Canadian position is that the settlements are a violation of Security Council resolutions, and they're also a violation of the Fourth Geneva Convention. So the second point I want to make is not only that the world has moved on and said not only are they illegal under international law, illegal under the Fourth Geneva Convention, the settlements are a war crime, beginning in 1977 with something called the Additional Protocols to the Geneva Conventions. But this was established most clearly in the adoption by many countries in the international community of the Rome Statute of the International Criminal Court in 1998, which came into effect in 2002. And the wording of the Rome Statute copies the wording directly coming from the Geneva Convention, which says that the transfer directly or indirectly by the occupying power of parts of its own civilian population into the territory it occupies is a war crime for the purposes of the statute. And this was endorsed most recently by the United Nations High Commissioner for Human Rights. He issues an annual report going to the Human Rights Council. He said in March 2023, his most recent report on the Israeli settlements, he says that such transfers of population amount to a war crime which may engage the individual criminal responsibility of those involved. So that's pretty clear, I think, under international law. The third point I want to make is that Canada has incorporated into our own domestic Canadian law all three primary provisions of international law that I've quoted from. It's incorporated the Fourth Geneva Convention into Canadian law. It's incorporated the protocols of 1977, which are additionals to the Fourth Geneva Convention into Canadian law. And it's also incorporated the Rome Statute of 1998 as the Crimes Against Humanity and War Crimes Act of 2000. So under each of those three pieces of Canadian legislation, it says that the transfer by an occupying power of parts of its civilian population into the occupied territory amounts to war crime. And when it amounts to a war crime, this actually puts a duty and an obligation on Canada to take steps to either bar someone who is on reasonable grounds suspected of being involved in a war crime from entering Canada, or conversely, if they enter Canada, to be able to arrest them and to try them, since what the Crimes Against Humanity and War Crimes Act sets up is this concept of universal jurisdiction, that a country that has passed this legislation incorporating the Rome Statute into Canadian law has now the jurisdiction to try somebody who's committed crimes, even if they're elsewhere, even if that person is not a Canadian citizen, as long as that person is found on Canadian soil. We've done this already with respect to a war criminal arising out of the Rwandan genocide of 1994, who was found in Canada, was tried and convicted with respect to that. So I want to emphasize that it's not a choice that Canada has. It's not a menu a la carte. It's a legal duty and an obligation that's clearly laid out in the legislation that we have there. It's not enough to say, in my closing remarks, it's not enough to say that we support forthright the application of international law in Syria for war crimes that have been committed there, for the application of international law in Russia in its occupation in Ukraine, but say international law, yes, it may matter with respect to the occupied Palestinian territory, but we're not going to enforce it, and we're not going to wind up advancing it. We don't have that choice. Those are obligations for any country that says it's an adherent to international human rights law and an adherent to international humanitarian law. And it's very clear that in the Crimes Against Humanity and War Crimes Act that's in our legislation, that someone who's committed any of these crimes, as Naftali Bennett would have, both as an employed spokesperson for the settlements before he became an Israeli politician, and as a member of the Israeli cabinet and an Israeli prime minister, that he had a direct hand in the protection and the expansion of the Israeli settlements. He would be prima facie guilty under Canadian law and under international law of committing these war crimes. Let me end it with that by saying that I trust the Canadian government will do the right thing in either barring him from entering Canada or charging him once he's on Canadian soil. Thank you very much.
Well, thank you. Thank you very much, Michael. Thank you for your comments and for enlightening us to your findings, as well as the position of the UN around the illegality of these Israeli settlements, their status as a war crime, and the obligations that Canada has as a result with regards to Bennett and this visit, this planned visit. It's very important to understand these details. I would like to draw your attention to an action, the audience to an action that is taking place. It's being organized by the Palestinian Youth Movement alongside Independent Jewish Voices in Toronto for Palestine, as well as Actions for Palestine and Students for Justice in Palestine at TMU. It starts at 6 p.m. in the Symes. This is for tomorrow, and it's a protest against the planned speech from Naftali Bennett. So do find out details of that if you're in the area. Thanks again, Michael. We look forward to hearing more from you during the Q&A. Next up, we have one of the lawyers who filed the complaint and mandamus application, Shane Martinez. Shane is a criminal and human rights lawyer and an adjunct professor at the Osgoode Hall Law School in Toronto. In addition to this case, Shane's work around the Israeli occupation has included complaints to the Canada Revenue Agency regarding alleged shell charities being used to raise money for the Israeli military. He also privately prosecuted the first ever criminal case against a Canadian organization for its involvement in recruiting volunteers for the IDF. Welcome, Shane.
Good afternoon. Thank you, Bianca, and thank you to all those in attendance today for joining us. And thank you to Khaled and to Professor Link for their valuable and insightful presentations as well. As I think many of you know, the request to exclude the former Israeli Prime Minister Naftali Bennett from Canada, it was filed with the CBSA because the signatories to it reasonably believed that Bennett committed or was a party to war crimes contrary to the Crimes Against Humanity and War Crimes Act. And therefore, it was requested that CBSA deny entry to Canada pursuant to the Immigration and Refugee Protection Act. And what I'm going to try to do in a short amount of time is to break down the relevant Canadian law and policy as it relates to this case. So first, let's look at what Canadian criminal law says with respect to war crimes. The federal government acknowledges that it has domestic and international legal obligations to exclude perpetrators of atrocities. And nearly 25 years ago, Canada signed the Rome Statute of the International Criminal Court, which formally committed Canada to this active role in criminalizing war crimes, crimes against humanity, and genocide. And that was followed by the passage of Canada's Crimes Against Humanity and War Crimes Act in 2000. Now, this legislative development effectively incorporated the Rome Statute and the Fourth Geneva Convention into domestic Canadian law. And today, Canada refers to itself as a global leader in holding persons who have committed war crimes, crimes against humanity, and genocide accountable. Section 6, sub 1 of Canada's Crimes Against Humanity and War Crimes Act states that every person who commits genocide, a crime against humanity, or a war crime outside of Canada is guilty of an indictable offense here and may be prosecuted for it. The Act goes on to state that Section 6, sub 1.1 makes it an offense to conspire to commit an offense or attempting to commit an offense. The Act also defines a war crime as an act or omission committed during an armed conflict that at the time and in the place of its commission constitutes a war crime according to customary international law or conventional international law applicable to armed conflicts, whether or not it constitutes a contravention of the law in force at the time and in the place of its commission. The Act provides further clarity on that still, and it says, for greater certainty, crimes described in Articles 6 and 7 and paragraph 2 of Article 8 of the Rome Statute are, as of July 17th, 1998, crimes according to customary international law and may be crimes according to customary international law before that date. This does not limit or prejudice in any way the application of existing or developing rules of international law. So what does all of this mean? Well, paragraph 2 of Article 8 of the Rome Statute is specifically cited in Canada's domestic war crimes legislation. And as Professor Link had set out in a report that he prepared that was part of the request to CBSA, paragraph 2 of Article 8 states that other serious violations of the laws and customs applicable in international armed conflict within the established framework of international law can amount to war crimes. And this includes the transfer, directly or indirectly, by the occupying power of parts of its own civilian population into the territory it occupies, or the deportation or transfer of all or parts of the population of the occupied territory within or outside this territory, right? Now, as was also explained by Professor Link in his report, and as in his comments today, illegal Israeli settlements precisely fit this definition. So in other words, a person who has been materially involved in the expansion of the illegal Israeli settlements, or someone who has conspired in illegal settlement activities or attempted to carry them out, may be guilty of a war crime under Canadian law. Even if that crime was committed outside Canada, our law is such that that person can be arrested, charged, and prosecuted for the offense here in this country. However, criminal prosecution, that's not the only way that war crimes legislation is enforced. So we can shift gears a little bit and look at what Canadian immigration law says with respect to war crimes. In an effort to kind of give preventative effect to Canadian law on war crimes, Canada's Immigration and Refugee Protection Act empowers the CBSA to exclude persons who are suspected of involvement in war crimes. And CBSA is empowered by Section 35 of the Immigration and Refugee Protection Act to deny entry to individuals who are reasonably believed to have been involved in or complicit with war crimes. In other words, individuals who are found inadmissible are not allowed to enter Canada. Furthermore, if the Minister of Public Safety, Marco Mendicino, believes that a foreign government engages in or has engaged in war crimes, then prescribed senior officials in the service of that government can be excluded from Canada as well, even if they weren't directly involved in the war crimes themselves. The policy of Immigration, Refugees, and Citizenship Canada states that persons who have committed or have been complicit in the commission of a war crime, regardless of when, where the crimes occurred, are not welcome in Canada. And CBSA, in collaboration with the RCMP and the Department of Justice, they operate something known as Canada's Crimes Against Humanity and War Crimes Program. And the objective of the program is twofold. First, it's to deny safe haven to war criminals and persons believed to have committed or been complicit in war crimes. And second, it's to contribute to the domestic and international fight against impunity for the perpetrators of such acts. And internal audits of the program and how it works show that during a 10-year period from approximately 2003 to 2013, CBSA denied 2,800 visa applications for individuals who were suspected to have committed or been complicit in crimes against humanity, war crimes, or genocide. And some of these denials of visas happened even where there was no proof at all that the traveler had been involved in an offense. Now, in addition to criminal law and immigration law, Canadian foreign policy is directly relevant to the issue as well. And to conclude my remarks today, I'll note that Canadian policy claims that it does not recognize permanent Israeli control over territories occupied in 1967, so the Golan Heights, the West Bank, East Jerusalem, the Gaza Strip. And it goes further to state that Israeli settlements in the occupied territories are a violation of the Fourth Geneva Convention. It also states that the settlements constitute a serious obstacle to achieving a comprehensive, just, and lasting peace. And in 2021, it was reported by the Canadian press that Foreign Affairs Minister Marc Garneau told his Israeli counterparts that evictions, demolitions, and the building of settlements in East Jerusalem should cease in order to ease tensions and prevent another round of violence in the region. And earlier this year, Melanie Joly, who's the Minister of Foreign Affairs, publicly stated that Canada strongly opposes the expansion of settlements. Such unilateral actions jeopardize efforts to achieve comprehensive, just, and lasting peace, and she stated that this is Canada's long-standing policy. However, as we know, actions speak louder than words, and if Canadian law is unenforced, it is really reduced to little more than words alone. And with that in mind, I'm now going to hand it over to my colleague, Nicholas Pope, to speak about the efforts that our team has undertaken in an attempt to force the government to give effect to the law. Thank you.
Thank you. Thank you so much, Shane. Thanks for helping us to just really understand the legislative framework for handling suspected war criminals. And congratulations to you again and to Nicholas for your incredible work. So I just want to quickly say, if you want to write to the minister, you can do so. We've put the link to do that in the chat. Please do take action. So now we're going to be hearing from Nicholas Pope. Nicholas practices administrative law at Hamid Law in Ottawa and worked with nonprofit organizations, including advocating for international law while working at the Civil Coalition for Palestinian Rights in Jerusalem. Welcome, Nicholas.
Thank you, Bianca, and thank you everyone for being here today. So as Shane mentioned, we submitted about 2 weeks ago on May 29th, a brief to the minister asking him to declare Naftali Bennett inadmissible. And once we submitted that brief, we waited until the end of the week. That was Monday that it was submitted. And then by Friday, we had received no response. So we filed an application in federal court to compel a response. And this application, as you've heard people mention, it's called a mandamus application. That's simply a Latin word for we command, which asks the court to command the minister to do his legal duty. And as mentioned, both by Michael and Shane, the minister here has multiple legal duties. So legal duties under customary international law, which are part of Canadian law. And duties under our own legislative framework to enforce immigration laws and to uphold our system. And so the minister has this legal duty, and we understand that this is a politically difficult matter for him. We're not deluded. We know there's controversy around this decision, but he cannot just simply avoid his legal duties. And so we're now waiting to hear back from the government lawyers. They've responded and said they're assigned to this file and have given us their notice of appearance. And we're waiting to hear back from them as to whether the minister will render a decision prior to Bennett arriving. Now, if the minister does not provide a written decision with reasons for the decision, whichever way it goes, then this will not absolve him of responsibility. because he will still have rendered a decision. If Naftali Bennett enters Canada today or tomorrow, then by letting Bennett in, Minister Mendicino will have impliedly found Bennett admissible to Canada. But without giving proper reasons, without a written decision, this decision will have little chance of standing. Because for a decision to withstand judicial review, it must be properly justified by way of its written reasons. And this was affirmed by the Supreme Court in 2019 in the landmark case of Vavilov. And so all that to say that without a written explanation for Bennett's admissibility or inadmissibility, it will likely be overturned. And so what we see ourselves doing here is giving the minister a reminder, do your duty. If you do not, that does not mean that there is no accountability. But if you do, then at least the minister has an opportunity first to explain. So if Naftali Bennett is allowed into Canada, regardless of whether reasons are provided or not, then, as I mentioned, especially if there are no reasons, it's likely the decision will be overturned after the fact. And this will not stop Mr. Bennett from speaking tomorrow. But what it will do is it will set a precedent for the future. It'll set a precedent that will stop events like this from happening in the future. And so, for the sake of doing what is right, we hope that Minister Mendicino will declare Bennett inadmissible before he arrives and uphold the law now. But even if he does not, we trust that the courts will do what they do. That is, they will uphold the law, and that any refusal to provide even reasons for his decision will only serve to ensure that this will never happen again. And so we ask Marco Mendicino, we ask the minister, be transparent, be upfront. If Naftali Bennett was complicit in war crimes, then do your duty. Do not let him into Canada. But if you do not think that Mr. Bennett was complicit in war crimes, then be transparent and explain this to the Canadian public. Thank you.
Thank you, Nicholas. Thank you so much. Thank you also just for enlightening us to the mandamus application and for your great efforts to use it to uphold the rule of law. So that is it for our panelist presentations this afternoon. Thank you so much to all of you. I'm going to shift gears and move into the Q&A session. I'm going to call now upon journalist Paul Salvatore from TRT World in Istanbul to ask his question. And Paul, you can direct this at an individual or towards the whole panel. Welcome, Paul.
Sure. Am I coming through?
You are.
Okay. Thank you so much, Bianca. Yeah, I actually, Nicholas already answered most of it in that last bit. I was just wondering if there's any penalty for the minister if he doesn't render a decision.
Yeah, thanks for the question. You're right. As I mentioned before, there's no financial penalty, nothing like that. But the penalty is that the decision to allow Mr. Bennett into the country will be much harder for the government to uphold if it goes to court afterwards, because of this justificatory burden on the government when rendering decisions. So without any reasons, it's almost impossible for a decision like that to stay intact.
Okay, thank you so much.
Thank you, Paul. Does anyone else want to speak to that? All right. So we're now going to take a couple of questions from audience members. Thank you so much to people who submitted both during and in advance of the session. We have a question from Elizabeth, who would like to know if Israel does formally annex the West Bank, does that make its Palestinian population citizens with the right to vote, etc.? Michael, what are your thoughts on this?
That's highly unlikely. If Israel went ahead to annex the territory or parts of the West Bank, it would, unless it was annexing only what is known and what Khaled referred to as Area C, where there's somewhere between 180 and 300,000 Palestinians, it may give them citizenship rights. But the guiding principle with respect to Israeli policy, particularly over the 56 years since the occupation began, is maximum land, minimum Arabs. And virtually every major Israeli leader has repeated that particular maxim. If it annexed all of the West Bank, which is 2.8 million Palestinians, it would probably it would almost certainly not give them citizenship rights, since that would significantly alter the demographic balance in Israel. What it probably would do is grant them the kind of residency status, the precarious residency status that the 350,000 Palestinians now living in occupied East Jerusalem wind up having. So either way, Israel will, as I said, would want to be able to ensure that it has the maximum length of territory they can to annex, with a minimum amount of Palestinians to either care for or would have any kind of rights under Israeli law. And one last thing, I want to make it clear to everybody that annexation is profoundly illegal under international law. It amounts to again a war crime and a crime against humanity under the Rome Statute. We have lived since 1945, since the end of the Second World War, and since the creation of the United Nations, with the no annexation rule. And while annexation still does occur, as we can see with respect to Russia and Ukraine, there remains a widespread understanding that is illegal, and it's happened much less frequently than the world before 1945.
Thank you so much. Thank you so much, Michael. We have a question from Mariam, who would like to know, what are potential settlers offered as encouragement to move to an occupied country? I think I'll direct that to Khaled.
Sorry, again, please repeat the question clearly.
What are potential settlers offered as encouragement to move to an occupied country? Why would people settle in occupied Palestine? What's the incentive?
Well, the incentive is first of all, they're providing them with financial incentives, because the cost of living in Israel proper is quite high, rents and all that. So that's one thing. The second thing is that they are supplied with all the amenities. They are building highways, especially for the settlers. They provide them with electricity and water, with all the facilities. At the same time, many of these settlers are extremists, in the sense that they believe this whole area between the river and the sea was given to them by God, and therefore it belongs to them, and whoever is living there is just a guest who has to abide by their demands, and they have a free hand at the same time to go into the Palestinian communities in the area, assault them, steal their cattle, use their farming lands, and they've been doing that successfully. And as an example, I will cite one example which happened during the reign of Bennett, which is the Masafer Yatta region in the West Bank. This is a region that had 8 Palestinian villages where 2,000 people live, and the government declared it a firing zone during that time, and the High Court of Justice ruled in favor of the government. So there is an eviction notice now, and since then they have allowed also at the same time, they have allowed outposts set up by Israeli settlers that can go into the lands of those villages, graze there, and do whatever they want. And this is why, as I said earlier, the main danger is not only the fact that the decision to allow settlers to go into the West Bank is a war crime, but the fact that these settlers, who many of them are actually soldiers in the Israeli army at the same time, they serve in the army, but they are, whenever they're off duty, they can do what they want, and they have full support from the government back in Tel Aviv to do whatever they want, and they will confiscate lands. They will steal the sheep. For example, in one case, one of the communities said that they had 2,500 sheep, and now they're down to 500 because they don't have grazing grounds, they don't have protection, they don't have water to water their farms. So all of that, you have these settlers are also committing a crime, because they are encouraging many of these Palestinian communities to leave the area. So they are internally displaced, which is a crime against humanity according to the statute of the International Criminal Court. So Bennett allowing Masafer Yatta in May of 2022 was committing both a war crime and crimes against humanity, because encouraging also the settlers to assault and persecute the Palestinians and force them to leave internally into another area.
Thank you so much, Khaled. That was very, very informative. We have a question from Tina, who wants to know, given the ineffectiveness of the ICC and UN in being able to enforce international law, how do we free Palestine from this oppression? It's a big question. Is there anyone who'd like to tackle this one? All right, I'm going to call on.
Okay,
Yes.
Repeat the question, please.
Given the ineffectiveness of the ICC, given the ineffectiveness of the UN in being able to enforce the law, international law, what should we do?
Well, unfortunately, the European Union and Canada and the United States are not putting any pressure on Israel, and that's clear. Israel. This is why Israel is doing all these things with impunity, because they know there's only talk, there's only condemnations, verbal condemnations, but nothing is taking place. Now, one development which is happening, which is the grounds in those countries, people are becoming aware of what's happening. What's happening is you have a nuclear power, which is whose army is more powerful than Canada, by the way. It's ranked 9th in the world, oppressing an indigenous population who is Semitic. So the Arabs are Semitic. I am a Christian Arab. I am a Semite, and I'm not allowed to go back because of my religious and ethnocultural identity. So if you believe as a citizen, as a Canadian citizen, the Charter of Rights, you cannot but say our government should be trying to do something to stop these crimes, this racism, this discrimination, this persecution against people because of their religious or ethnocultural identity. And that's why social media is doing the job. Unfortunately, until now, our political leaders, most of them are silent, are not doing any action. The mainstream media also does not provide proper coverage. they always try to depict this as a security issue for Israel. And an occupier does not deserve security from the occupied. The occupied people are the ones who need the security and the protection by the European Union, by Canada, by the United States. And that's why the groundswell, the pressure that's coming from the rank and file of Canadians to the politicians will slowly, hopefully, turn the tide. That's what happened in South Africa. Initially, the churches didn't speak out, the politicians didn't speak out, but slowly it took time, it took decades until Canada finally took action and started imposing sanctions on a racist regime that's committing war crimes and crimes against humanity.
Thank you. Powerful words. We have a question submitted in advance. Could the panelists speak more specifically about what Bennett's actions while he was Prime Minister and also Minister of Defense in regard to settlement expansion? It would be great to just elaborate on this a little bit, given that this event is so specific. I'll turn to maybe Shane or Nicholas.
Sure. Thanks, Bianca. I guess there's two parts of Bennett's involvement in this. So between 2010 and 2012, as Michael had noted, Bennett served as the director of something known as the Yesha Council. And according to the Yesha Council's own website, it states that it, quote, works to establish and expand the settlement enterprise throughout Judea and Samaria, the West Bank. And it subscribes to a belief that it has a moral and natural right to the land of Israel and is opposed to handing over parts of it to, quote, the enemy. One of its stated goals is, quote, to prevent the establishment of a Palestinian state between the Jordan River and the Mediterranean Sea, end quote. So remember, he was a director of this organization prior to becoming the prime minister. He then served as the Minister of Defense from 2019 to 2020, and then served as the Prime Minister from 2021 to 2022. And the IDF has, of course, been central to the expansion of illegal settlements as well. It's been widely reported by the New York Times, the Associated Press, and others that almost immediately after becoming Prime Minister, he embarked on a mission to expand illegal Israeli settlements. It was reported that a Defense Ministry Planning Committee approved the construction of 3,130 new homes very shortly after he was elected, and that was spread across 25 existing settlements. Most of them were deep inside the West Bank. The Israeli Ministry of Foreign Affairs also put out a press release in December of 2021 announcing that Cabinet had approved what they called an unprecedented plan to invest in the Golan Heights in order to double the population there within 5 years. And Bennett was described in that press release as leading the decision. There's other sources as well with respect to his involvement. He's quoted by the Associated Press as saying, in the face of enemy violence, the Zionist answer has always been settlement, security, and immigration. And in addition to that, his activities have been quite meticulously tracked by a group called Settlement Watch, which is run by, it's kind of a subgroup of another organization called Peace Now. And kind of the Canadian branch of Peace Now notes that the Bennett-Lapid government promoted plans for 7,292 housing units in the settlements, which was a 26% increase over the annual average of such plans by the Netanyahu government, or governments plural of the past. So there's substantial and significant researching that has taken place around Bennett's involvement in the expansion of illegal settlements. This is just scratching the surface, but gives you an example of what's going on.
Thank you. Is there any nexus between the expansion of illegal settlements and violence by settlers? Is the next question.
Well, as I said earlier, you know, the ideology of the State of Israel is to acquire not only the land between the Jordan River and the Mediterranean Sea, but even beyond that, because there are extremists within that government, which even refer to parts of Jordan, parts of Lebanon, parts of Syria, by saying this was all granted to them by God, you know. So there is that mentality. At the same time, they have been encouraged by the fact that neighboring Arab states have signed peace treaty with them. Now you have Egypt, Jordan, United Arab Emirates, Morocco, Bahrain, Sudan. And so you have 6 major Arab countries who have really recognized Israel, you know, and have peace. So there's no real, you know, threat to Israel's security. So when you have people who believe in this mentality of superiority, who look at Palestinian Christians and Muslims as inferior people, who believe this land can be taken at any time, you know, and they are not only doing that in the West Bank, in the Golan Heights, in East Jerusalem. They have even now passed you know, statements by the government saying we should Judaize the Galilee and the Negev. These are major parts of Israel. The Negev comprises 60% of the land area of Israel proper. The Galilee comprises about 10% in the north. They want also to change the demographics of those areas, because the Galilee has a majority of Arab Palestinians. The Negev has about 30%, which they think is too high, of Arab Palestinians. They need the land, but at the same time, they don't need the people. And that's why they have clearly stated, our idea is, you know, we want all the land. If the Palestinians accept it, we'll let them stay as inferior human beings. But if they resist, we will certainly, you know, arrest them or kill them. And we will also encourage them to leave, because we want to ensure that we have a majority. They really do not accept more than 20% Palestinian Arabs. In Israel proper, there was 21%. But now, if you include the West Bank, you would end up with more than 35%. So that would endanger the Jewish character of the state. This is a government led by an ideology which bases itself on a superiority of identity. If you're religious, you speak Hebrew. If you don't belong to those identities, then you have no rights, and anything is acceptable to maintain the purity of the state.
Thank you, Khaled.
I wonder if I could just add to that. You know, I think the question had asked whether or not, with the growth in settlement population and settlements, has there been an increase in settler violence towards Palestinians? And the answer is most emphatically yes. 2022 was for those who monitor attacks on Palestinians by settlers, was the highest number of settler attacks since this issue was began to be documented and recorded, which I believe is 2008, and certainly figures with respect to the first 5 months of 2023 indicate that settler violence is growing at even a faster rate than in 2022. And what the violence consists of is, sometimes directly stealing land, sometimes cutting down olive trees, olive trees being obviously a significant part of the rural agricultural Palestinian economy. As Khaled mentioned, sometimes stealing sheep, but sometimes just attacks on either individual homes or on farms or on towns and villages. There was an infamous attack several months ago on a Palestinian village near Ramallah, where a number of cars were burned, homes were burned, Palestinians were attacked. One Palestinian was killed by settlers from a nearby well-established settlement, not simply one of these hillside settlements, but from a long-lasting settlement in the area. So I think it would probably be fair to say that many Palestinians, particularly those in more isolated and rural communities and farms, live in abject fear with respect to being close to settlers and facing their ongoing wrath, sometimes in entirely unprovoked activities by them.
Well,
Yeah,
thank you.
actually, I would just like to add to that. The settlers are not, acting outside of a framework. First of all, you have a government which supports the settlers. Second, you have the military, which is in the occupied areas, which protects the settlers. Like the settlers can go into any place and burn or attack, and the military protects them. And at the same time, the courts makes decisions that give more power to the settlers. For example, you have recently the Homesh outpost, which is in the West Bank, which was illegal before. The courts ruled that they can go back and live there. And so they were supported by the courts. They were supported by the government. The government is providing them with electricity and water. And they in the end, have free hand to do what they want, because this is a multiple group. The settlers are the people in the field, but they have the government out there, and then you have the military supporting them and encouraging and not charging them with any crimes that they do.
Thank you. Thank you so much, Khaled. So we have people at home are clearly really interested in knowing about next steps. We have a question, two questions actually, same question. Will you pursue legal action against the Canadian government for letting Bennett in? Nicholas.
Thank you. So all legal options will remain on the table, whether that's a judicial review of any decision or a private prosecution or any other manner of many various legal means that are at our disposal. But we're optimistic that Minister Mendicino will do the right thing and we won't need to take any further steps. But if Naftali Bennett is allowed into Canada, then we will carefully review any reasons for the decision and make a determination as to our next steps at that point in time.
Thank you, Nicholas. The final question that we have here, if Bennett is allowed into Canada, what does this say about Canada's policy regarding settlements, and more specifically about Canada's upholding of its own domestic laws? Thoughts on that? Shane, Michael?
Shane, go ahead.
Oh, thanks, Michael. I guess my short comment on that would be that I wouldn't be surprised, but I would nevertheless be disappointed. I think that when it comes to making change on issues like this, it's not something that the government does benevolently or willingly. As I mentioned earlier, actions speak louder than words. Canada has its foreign policy with respect to Israel-Palestine, but its actions are oftentimes in contradiction to that and present a bit of a hypocrisy. So when we want to make sure that the rule of law is upheld and that international law is respected and that our law is enforced, it really takes mobilization of the people and raising of awareness to force the government to do the right thing.
Thank you, Shane. Michael.
Look, the government has two options, has a number of options. One option is to prevent him from coming in. A second option would be to arrest him if he's on Canadian soil. Both of those would be within the realm of obligations on the Canadian government. If it is neither, then I'm hopeful that the actions that Shane and Nicholas have initiated would wind up, first of all, forcing a statement of reasons as to why the Canadian government didn't take those steps. And if they're inadequate, if they cannot explain why they distinguish in the case of Mr. Bennett as opposed to all of the other denied applicants who may have been suspected of war crimes that Shane and Nicholas had referred to earlier, then I hope there will be a process by which the court can pronounce on the obligations that the Canadian government clearly has under the War Crimes and Crimes Against Humanity Act.
Thank you, Michael. Actually, on that note, there is one last question that was just posted on the same subject. Leslie wants to know, could Bennett not be arrested for crimes against humanity and turned over to the international community, international court?
I think the answer is the international court. It could be turned over to him, but quite frankly, the better situation would be a trial in Canada. We've done that before with respect to Rwandan suspected war criminals. We have the power under universal jurisdiction, and is granted to itself by the Crimes Against Humanity and War Crimes Act, to try a suspected war criminal in Canada, in Canadian courts, for an international crime that was committed someplace else. That would seem to be the both the option that would be closest to a legal obligation that Canada would wind up having, and probably the right thing to do.
Thank you, Michael. So we're coming to the end of our event. This has been so informative. I'm just going to turn it back over to the panel very briefly to just give us a last word before we close out. And I'm going to start with you, Shane.
Well, thank you, Bianca. I don't have much else to say at this point, except again, thanking everyone for their attendance and participation today. Special thanks to Khaled and to Michael as well. Just amazing, incredibly valuable insight from both of them. I know that it's of great assistance to Nicholas and I in preparing cases like this. So thank you to both of them. Thank you to everybody for your support, and the struggle continues. Thank you.
Thank you, Shane. Nicholas.
I'd echo Shane. Thanks everyone for being here. And I'd say just keep a close watch as to what unfolds over the next 24 hours with this. A decision will be rendered either way. The question is whether Minister Mendicino will be transparent about that decision or not transparent. And of course, if he's not transparent, well, if I were Naftali Bennett's counsel, and I'm not, and sir, if you're on this call, this is not legal advice for you, but if I was his counsel, I would be also echoing our request to the government, asking the government to render a thoroughly written decision that addresses all of our points, all of our evidence, because otherwise the decision will be very vulnerable to being overturned in federal court. And so I think all people can agree that transparency in these issues is vitally important. And so we ask the government to do that.
Thank you, Nicholas. Michael.
Lawyers are used to dealing with gray, with many different shades of gray, probably more than 50 shades of gray. It's rare to come across a legal issue where the law is so straightforward, so clear, and so unambiguous with respect to A, the illegality of the Israeli settlements that amounts to a war crime under both international and domestic law, and B, what the duty and obligation of a government is with respect to somebody who is intimately connected with those war crimes coming to Canadian soil.
Thank you, Michael. Khaled.
Well, as a Palestinian, who was forced to leave Haifa at a time when there were 70,000 Arabs in Haifa in 1948, and within a couple of months, extremist Haganah militia were able to deport or force to leave 68,000 of them, and only 2,000 remained. This is the catastrophe that I went through as a 6-year-old boy with my grandmother and elder brother. And I don't want the same thing to happen to the 3.4 million Palestinians in East Jerusalem and the West Bank who face the same threat from hundreds of thousands of armed militia supported by a nuclear power which has an army that is stronger than Canada, that is using all means and methods to frighten and to dispossess these Palestinians in the West Bank and East Jerusalem and the people in the Golan Heights. They are capable of doing that if we don't have a government that insists on implementing its laws and telling them, these are crimes against humanity, these are war crimes, and Canada will not tolerate them and be silent. We have to prevent another catastrophe, because this is the plan that the Israeli authorities have said clearly. We want all this land, but we don't want the people. Anybody who resists will be deported or killed or imprisoned. And those who accept have to live as inferior human beings under our command and do whatever we want. So let us prevent another catastrophe that I and hundreds of thousands of Palestinians went through in 1948. The same thing is being planned by this nuclear power, which has impunity so far from the European Union, Canada, and the United States. Thank you.
Thank you, Khaled, and thank you to all panelists for those excellent summaries. We've come to the end of our event. Thank you so much to our panelists. Thank you to the organizing groups, including those that endorsed. Thank you to the audience, and thank you also for your questions. Thank you to Karen Rodman for all of your work in the background today, as well as for your terrific organizing around this event. Thanks to Bruce Katz as well for being available for translation. You can follow up on the next steps through any of our 3 organizations, Just Peace Advocates, Canadian Foreign Policy Institute, or PAJU. Thanks again to Shane, to Khaled, to Nicholas, and Michael for sharing your knowledge and work with all of us. This was incredibly informative. Also, I want to extend my congratulations on the campaign. This work is clearly having an impact. So thank you very much. Freedom for Palestine. That's it for our program, everybody. Peace and good afternoon.
Thank you very much.